Please be advised that U.S. Citizenship and Immigration Services is closed for all in-person interviews and services until at least June 15, 2020. Please be advised that all immigration court hearings for immigrants who are not detained are canceled through at least June 26, 2020. This presentation is part of a series of video trainings put together by the Urban Justice Center's Domestic Violence Project. This training is on the U non-immigrant status, commonly known as U visa. This training is designed to provide general information about U visas. It is not intended to provide legal advice or guidance on any particular case or matter. When in doubt, consult a lawyer. The U visa is available to non-citizen victims of certain crimes, lasts 4 years, provides work authorization, allows family reunification, and creates a pathway to lawful permanent residence after 3 years of having non-immigrant status. The number of petitioners greatly exceeds the number of available U visas, which is limited to 10,000 visas per year. When a U visa is unavailable upon filing, USCIS reviews the case, if approvable, grants conditional approval, places the case on a wait list, and grants the petitioner and the derivatives in the US deferred action. Deferred action is not a legal status, but the petitioner and any derivatives in the US can obtain work authorization, and derivatives abroad are in theory able to gain lawful entry to the US via humanitarian parole, although in practice this is rarely available. To be eligible for a U visa, an individual must be a victim of a qualifying criminal activity such as domestic violence, rape, sexual assault, murder, kidnapping, stalking, false imprisonment, or other violent crimes. This is only a partial list. The crime occurred in the United States or violated US law. The victim possesses information about the crime. The victim is helpful to law enforcement agency in investigating or prosecuting the crime. The victim suffered substantial physical or mental harm as a result of the crime, and the victim is not inadmissible. Now we will be discussing each element separately. Being a victim of a qualifying criminal activity means that the individual is either a direct or an indirect victim. A direct victim is someone who was directly and proximately harmed, or a bystander who suffered unusual harm by witnessing a crime. An indirect victim is someone whose family members suffered a direct harm and who may be considered a victim in cases like murder, manslaughter, or in cases involving incompetent or incapacitated victims. For crime victims who are age 21 or older, their spouse and unmarried children under 21 may be considered indirect victims. For victims under age 21, their parents and unmarried siblings under 18 can be considered indirect victims. Another required element is that the victim must possess information about the crime. This means that the victim has knowledge of specific facts that assisted, are assisting, or will assist the law enforcement agency in the investigation or prosecution of the crime. The next element is that the victim must be helpful to law enforcement in the investigation or prosecution of the crime. Law enforcement is defined broadly, including the prosecutor, the judge, the police department, or other agency charged with investigating the crime. The person must not unreasonably refuse to cooperate in the investigation or prosecution. The cooperation with law enforcement agencies is established via a law enforcement certification. The certification must be signed by the law enforcement agent, is valid only for 6 months after signing, and must be submitted in the original form. The next element is that the victim must have suffered substantial physical or mental harm as a result of the crime. Physical or mental harm is defined by law as injury or harm to the victim's physical person, or harm or impairment of the emotional or psychological soundness of the victim. Whether the victim was substantially harmed is determined by the following factors: the nature of the injury, the severity of the perpetrator's conduct, the severity of the harm, the duration of the harm, the pattern of the harm, and the existence of permanent or serious injury. An aggravation of a previous condition can suffice. To be eligible for U visa, the individual must be admissible to the United States. When seeking admission to the U.S., an individual must meet all applicable statutory requirements and demonstrate that she is not inadmissible. Common grounds on inadmissibility include entry without inspection, criminal convictions, lack of passport, false claims to USCIS, misrepresentation to immigration officials, prior removals. In the context of U visas, the Department of Homeland Security has the authority to waive the grounds of inadmissibility if such waiver is in the public interest or national interest. This waiver applies to any ground of inadmissibility with a few exceptions, namely for participants in Nazi persecution, genocide, torture, or extrajudicial killings. U petitioners are able to include certain family members in the application process. These family members are known as derivatives. The qualifying family members are: for petitioners age 20 and under, the derivatives are the spouse, the children, the parents, and the unmarried siblings under 18 years of age. The age is established on the date when the petitioner applied for status. For petitioners age 21 or older, the derivatives are the spouse and the children. The family members cannot receive your non-immigrant status until the principal petitioner does, and they must get U status before the principal adjusts status to legal permanent resident. The adjustment of status requirements are the following. After 3 years of U non-immigrant status, the petitioner and the beneficiaries may apply for lawful permanent resident status if they are physically present in the United States in U non-immigrant status for at least 3 years, can demonstrate to USCIS that the adjustment of status is necessary based on humanitarian grounds to ensure family unity or in the public interest, and there is no affirmative finding that the non-citizen has unreasonably withheld assistance to law enforcement. There is no cap on the number of adjustments. This concludes the presentation on the U non-immigrant status. Thank you for listening, and I hope you found this information helpful.